Welcome everyone, either on the web and in the room. It's a great pleasure for us to welcome you. Tu as une place devant si tu veux. To welcome you all in the room. You have places if you want here. We are very happy to host this event again this year with BSP and with two English friends today, which will address the topic for the other side of the channel. For this brilliant topic, Tainted arbitration, we have superstars coming from Luxembourg. Laure-Hélène Gassio-Fievez, partner with BSP Luxembourg. Fabio Trevisan, a partner with BSP Luxembourg. Jason deserves a big thanks because you've seen on the program, Keith Oliver was supposed to be here, and there are some personal issues, and Jason accepted yesterday to replace him. So Jason Woodland is a partner with Peters & Peters, prominent English firm. We are very happy to work with frequently, and we are very happy to have you on board today, Jason, and thank you for saving the event because you you discovered the topic yesterday afternoon, and you've been working all day long and all night long, I suppose, to save your afternoon. And for such a topic, we needed to have an investigator, and we have you, Sebastian Neve. Sebastian is investigator in London with J.S. Held. That's J.S. Held. And Sebastian, you will address the topic on the English side of the channel. So thank you all for coming, and without delaying more your impatience, I give the mic to Fabio.
Thank you, Jack. Thank you for hosting the event. Thank you for the presentation. So how did we come along to this subject? The occasion was that very recently in France, there was a change in case law concerning the admissibility of evidence obtained by unfair means. And of course, we all know that the arbitration community is increasingly interested and wants to have arbitration proceedings and the awards that come out of it cleaner and irreproachable. So in France, at the enforcement stage or in the setting aside proceedings, whenever an award is challenged for a breach of international public policy, the allegations are fully examined by the French courts in the merits. There have been some recent decisions very prominent. No, these two trends we thought have in common is that they want the search for the truth. They also involve considerations of fairness in the conduct of the proceedings. And as we exchanged views until this morning with my friends here, coming from France and UK, and discussing the role of counsel, who is faced with unfairly obtained evidence or suspicions of fraud in the arbitral process, we realized that our legal traditions have significant differences. And this is exactly what we would like to address today. So we look forward, of course, to hear from the experiences, and if we can go, yes, to the what the evidence, what the program on the fraud in arbitration speaks about. We'll first speak about the tainted evidence, then the tainted proceedings, and of course, resulting in a tainted award. Now, the perspective that we'll look at is a lawyer who is presented with fraudulent elements at the different stage of the proceedings. First, counsel can be presented with evidence which may be fraudulently obtained. Second, counsel could suspect fraud in the organization of the arbitration itself. And third, counsel who is engaged at the stage of the enforcement of an award, which would allegedly result from fraudulent proceedings or would fail to sanction fraudulent behavior on the merits and what happens there. So from the lawyer's perspective, there is a mix and a balance between the ethics, the duty of the client, which is of course to take all necessary steps to defend in the best interest of their client, the duty to the court in certain circumstances, and what is this duty, and of course ultimately civil or even criminal liability. So that is the ultimate test. So I will now hand it over to Jacques, who will talk to us on the tainted evidence part from the French perspective.
Well, the French side will be addressed by the blue diamond of Valérion, who is Marie-Hélène. I did not introduce Marie-Hélène before because I thought she deserved a special introduction. So the French presentation will be done by Marie-Hélène. And first, I'd just like to briefly introduce the topic of tainted evidence. When as lawyer we meet a client who presents evidence when we are in charge of future or ongoing arbitration. We are presented with evidence that might be relevant on the merits, but dubious as to its origin or authenticity. This is what we refer to as tainted evidence. In fact, we mean two very different situations. The first is evidence which we as lawyers suspect that may have been fabricated, or it may be authentic evidence but obtained through illicit or unfair means. This refers to very different types of evidence. Of course, we have fabricated evidence, forged documents, unlawfully obtained evidence, such as authentic evidence but obtained through a process violating the law, for instance, physical or electronic intrusion. And we have unfairly obtained evidence. These are authentic evidence, but authentic evidence obtained without breaching any particular rule, but obtained in a way that violates fairness. That's, for instance, the case of evidence obtained in a clandestine manner, such as audio or video recording without the consent of the person. And we have a gray zone on which it will be interesting to have your comment, Sébastien, which is the evidence obtained by a non-party to the dispute upon instructions. So where do we stand as lawyers? How do we have to handle this kind of evidence? And of course, this is a big topic in arbitration, evidence obtained through leaks. What should we do as lawyers? Of course, we have to present evidence relevant to the case, admissible, and we have to avoid being liable for civil or criminal aspects, and of course we have to avoid any risk for the client. For this, we have the various rules. First of which, we have the UNCITRAL rules that gives a discretionary power to the arbitral tribunal. We know. Yeah, we have a ghost. We have a ghost in the room. We have the UNCITRAL rules. We have the IBA rules that gives at Article 9.2 and 9.3 two different situations. Situation in which the tribunal shall, at the request of a party or on its own motion, exclude from evidence several types of evidence, such as evidence coming from that represent legal impediment or privileged information. For evidence, we definitely have a ghost. Information that may infringe commercial or technical confidentiality, or evidence that may raise issues regarding fairness, equality of the parties. And we have situations in which the tribunal may, at the request of a party or on its own motion, exclude evidence obtained illegally. So there is a big role given to the tribunal. The tribunal will take into account, of course, due process requirement, such as legal duty of good faith, and we will see that in the case law, the duty of good faith is really very important. Respect of the equality of arms, principles of equal treatment and procedural fairness, and right to submit relevant evidence. The tribunal will also take into account obligation to render an enforceable award, which means that the tribunal will have to take into account the procedural public policy of the places of enforcement and seat of arbitration. And we know that in France it may be different than in other places. So the tribunal and the lawyers will have to balance between the process and circumstances through which the material was obtained. In the common law system, we have the doctrine of clean hands. It's a bit different in continental countries. And we will have to exclude evidence infringing legal privilege. In the balance, we'll have to take into account the probative value and relevance of the evidence in itself. There are plenty of case law related to these topics. We have the list on the slides. We don't have time to go into them, but let's keep in mind Metanex case and Libanco versus Turkey, who insist on the duty of good faith. To address the difficulty of the main difficulty in this topic, which is the difference of legal culture between councils and arbitrators, depending on which country they come from, on which kind of professional rules they rely on, we may face real difficulties. So to face these difficulties, there are several attempts to address the differences in legal culture through international guidelines that have been adopted to set forth council's duties, such as, of course, the IBA guidelines. We all deal regularly with the IBA guidelines. And Article 17 of the IBA guidelines addresses this issue when they say that a party representative should advise the party whom he or she represents of the necessity of producing the document and the consequences of failing to do so. So there is a real responsibility for the council. We also have the annex to LCIA rules or ICDR standards that try to address this topic of professional rules with evidence. ICC has a different approach and decided not to adopt any specific rules, but to say in a note that parties and their representative are expected to abide by the highest standards of integrity and honesty. So we see that here the common principle is a principle of fairness in arbitral proceeding. The question is how this principle is understood and applied from one jurisdiction to another. And maybe we can start with the French part. Marie-Hélène, if you don't mind.
Thank you, Jacques. Okay, you can hear me. I hope it will work without any ghost interfering. Well, first, I will say a few words about the admissibility of the evidence and then maybe focus on the counsel's duties. Because the first duty you have as a counsel is to assess the evidence and decide whether it is admissible or not, and then they are other rules which may have an effect on your decision to use it ultimately. So first, is it even admissible? I will start with a few provisions of French law, which are on the slide. So Article 1464 of the Code of Civil Procedure, which establishes the principle of fairness in the conduct of proceedings. Then, of course, I will not have to present Article 6.1 of the ECHR. I think you're all familiar with it, due process. And then Article 9. Okay, it's funny. First time it works like that, but okay, we'll manage. Article 9 of the Civil Code of the Code of Civil Procedure, which is in French, il incombe à chaque partie de prouver conformément à la loi les faits nécessaires. So it is for each party to prove in accordance with the law the facts necessary for the success of its claim. So it's quite clear. We don't even know why we are speaking about that. The principle is that only lawfully and fairly obtained evidence seems to be admissible if we just stick to the code. But it's a bit more complicated. First, Jacques spoke about forged evidence, witness tampering, fabricated evidence. Of course, I will not be long on that subject. Forged evidence fabricated evidence is of course not admissible, and it even opens the door to civil and criminal liability. But what about authentic evidence obtained through unlawful or unfair means? Well, the answer used to be quite straightforward. It was not admissible under French law, or at least in civil and commercial proceedings. It was a bit different in criminal proceedings. But now the answer is a bit more complicated, because we have a new decision from the Cour de Cassation plenary session, so the biggest session of the Court, the most important one, a decision of December 22nd of last year, which changes the landscape on this. Previously, we had a distinction to be made since 2007 between unlawful evidence and unfair evidence. The commercial chamber of the Cour de Cassation in 2007 decided that there was a right to evidence which allowed unlawful evidence to be declared admissible, where such evidence was essential to the success of the claim, and if the infringement of the conflicting rights in question was strictly proportionate to the aim pursued. So two conditions: necessity, you could not prove your point without using the evidence, and the infringement of the rights, for instance, the rights to privacy, the infringement of the rights of the other party was proportionate to the aim pursued. If you kill someone to have the evidence, it's not proportionate. So that was the principle regarding unlawful evidence. In this case, maybe to make this a bit more easy to understand, the facts were that one of the parties submitted medical records which had been obtained without any stratagem, obtained legally, but still there were medical records. And their submission violated the right to privacy, but it was considered as proportionate to the aim pursued in these proceedings. The plenary session of the Cour de Cassation then decided in 2011 that by contrast, you could not submit evidence gathered by stratagem, trickery, without someone's consent. If there was this stratagem or trick, the evidence would not be admissible. So that was the status of the issue before this decision of last year, of December last year, which unified the rules regarding unlawful and unfairly obtained evidence. Now, the test I just described, necessity of the evidence for the success of your claim and proportionality of the violation of the rules to privacy or other rules. Proportionality to the aim pursued. These two conditions, if they are met, make the evidence admissible, even if it was obtained unfairly. For instance, audio recordings without someone's consent is admissible now if it was the only way to prove your point, to make your case succeed, and if this violation was proportionate. So fairness is still the rule, but there are exceptions now. What are the consequences on arbitration proceedings? Okay, I have to hurry. The consequences, this decision is not about arbitration law. It's a purely domestic decision. But sometimes French procedural law applies to the admissibility of evidence, so it may be relevant. And we can think of issues, we can think of some cases where it may have an incidence on the arbitral tribunal's decision if the seat of arbitration is France, to know what French procedural public policy is. And now that we admit unfairly obtained evidence subject to some conditions, we can safely say that an arbitral tribunal may decide to admit evidence obtained unfairly without breaching French procedural public policy. And that's an interesting point for arbitrators. I will not say anything about this decision, but the Paris court anticipated the Cour de Cassation's decision in October 2023, so I just refer to this case, Hisense, I don't know how it's pronounced, where the double test was applied to admit unfairly obtained evidence in proceedings which were setting aside proceedings against an arbitral award. Then a few words about the Council's perspective. I'm a bit too long, I think. Sorry. Well, under French law, of course, we must behave fairly. It's in our code of ethics. And of course, we must warn the client about all the risk entailed with his decision to use or not to use unfairly obtained evidence. And just one word about that. What kind of risk? I said that that kind of evidence was admissible subject to a double test. But what if the test is not met in the end? You may think it will be met, but in the end, the court decides. And if the court decides that the test is not met, then the client may be convicted for a violation of sometimes criminal law. Like audio recordings under French law without someone's consent is a criminal offense. And just one word about the duty to the court. We do not have any obligation as a French lawyer to guarantee the authenticity and the truth of the evidence we submit or of the things we say. We cannot mislead the court intentionally, but if we are not aware that something is not truthful, something is false, then we are not breaching any professional rule. And the key word is aware. And so there is a duty to be vigilant, to be careful, but we do not have a duty to check everything. And there has been a decision from the Paris Criminal Court who dismissed a case against two French lawyers who had submitted forged evidence without knowing it was forged. So I think I will just end with this idea, conclude that we just have to be vigilant, but we may have to use unfairly obtained evidence and to warn the client about the risks entailed.
Thank you very much. Hope you can all hear me well. As with a lot of things coming from the United Kingdom, I'm going to offer a slightly different perspective on evidence perhaps improperly obtained. And I think this perhaps flows from the English approach to disclosure and sort of cards on the table approach. Anything relevant has to be disclosed to the court or tribunal. And so the general rule in England is that evidence, provided it is relevant, is admissible. And the fact that it has been obtained in, shall we say, dubious circumstances doesn't matter. Obviously, you might get extreme cases where the way in which the evidence was obtained was so extreme that it calls into doubt the reliability of that evidence. But there's no general rule that the evidence has to be obtained in a lawful manner. there's no sort of weighing of proportionality, the breach of the law versus the benefit of the evidence. And so we can see there a quote from a fairly recent case where I'm glad to see the English courts are putting torture to one side as sort of really beyond the pale. But short of that, and actually, privileged information, I would say probably comes within its own sort of slightly different category, where courts would be much more cautious about it. But generally speaking, if the evidence is relevant, that the English court is going to let it in, and I think that sort of gives you quite a good steer about how any English arbitrators are going to view it, how any English court is going to view a sort of enforcement challenge to an arbitration. And I thought I would just sort of give this an illustration through a case that we were involved in, where a client, the claimant, had obtained information from the Russian border service about the defendants coming and going from Russia. So every time you go to Russia, they log you coming in, going out, and so on. And that was relevant to a jurisdiction challenge because the time that the defendant spent in England was relevant to whether he was resident in England and therefore whether he could be sued there. And the court was presented with this data. The claimant said that he had obtained it through investigators by buying it through a radio market in Moscow, which Sebastian will know much more about than I do, but I understand is or used to be sort of fairly common way of getting information like this. So the English court was sort of faced with a question of, well, what do we do about this evidence? Because coming at it, from an English lawyer's perspective, you would think, well, gosh, this is material which shouldn't be available to the public. It's sort of captured by the government as part of its role. You wouldn't necessarily expect to see information from the UK Immigration Service sort of being made available in this way. And so there was a prospect of the court having to make sort of factual findings about how was this evidence obtained, and then also evidence under Russian law about actually whether that was unlawful or not. And there was quite a sort of exchange of evidence about all of that. But the judge took, I think, the entirely pragmatic decision of saying, I don't need to decide this. There was no debate about the reliability of the evidence. And so she took quite a sort of pragmatic view that it was there, it was relevant material that the English court should take into account. And so there wasn't any need for what effectively would have been a mini trial about how the evidence had been obtained, whether in fact it was a breach of Russian law, and if so, so what. So obviously material gathered in unusual ways can have serious consequences for the people who gather it, and those can be very serious indeed, including criminal prosecutions and so on. But as for its sort of availability for use in proceedings in England, that I think we have probably a slightly easier job than you do in France in trying to balance everything up. So on that note, I'm going to pass over to Sebastian.
Thank you. I think everyone can hear me through that. I am the investigator on the panel. I'm the naughty boy in the corner, if you like. In some ways, this panel is sort of carte blanche to say mean things about some of the people who do the job that I do, but it's more than that. I think that some of the sort of publicised instances of people getting things wrong, if you like, are things that we can all learn from, both lawyers and investigators. And with that in mind, I wanted to sort of run through a few examples of where things have gone wrong, and also perhaps some examples of using information that has come from a sort of grey zone successfully, if I can put it that way. To sort of wind back, there are sort of three main places that we can get our information from, and they are the public domain, the open source, which to my mind is basically anything that someone with an internet connection and a credit card can get hold of. The second is talking to people. There are various ways to convince people they might want to talk to you, to be introduced to them, whatever it might be. But I think that is ultimately where a lot of this stuff does stem from. And then the third is what we sometimes call the semi-public, which, you know, some people will certainly include Russian travel data. I think things have come on a little bit since buying hard disks from some of these beautiful covered markets in Moscow, which are slightly less accessible these days. But there are sort of all sorts of Telegram bots, I'm told, that one can go and fire questions at, and they will send you data back. And how one pays for it, I think you start sort of wandering into the realms of cryptocurrency and so on. But in reality, in Russia, anything is available. And if you look at yourself with a critical eye, you have to admit that at some point along the chain, someone has broken some sort of law or rule to get that data into your possession. I think one of the cases that I'm conscious I don't have too much time, but one of the cases I wanted to talk a little bit about is important because it tells you about how in practice some investigators will work and not necessarily know who is doing the work for them. And that's where we get instances of perhaps sort of forged information being deployed in arbitration or in court proceedings. And that case actually is related to the Rakia judgment that you mentioned earlier, Jason. And what happened there was the task that was given to the investigator was, something's really going on, I think. The task that was given to the investigator was, please can you tell us who is paying the legal bills of this criminal law firm in London? And the investigator who was tasked to do this contacted someone and said, can you get me the banking information for this law firm? They tasked someone else who the investigator didn't know. And that person, obviously took on a bit of a crisis of conscience, marched straight into the law firm and said, I've been tasked with trying to get hold of your confidential banking information by this person. So the lawyer in question and the subcontractor put their heads together, created a fake document of false banking information, put a PDF tracker on it and sent it back up the chain. And you can imagine that this caused some proceedings of its own down the line. And I think it's, you know, I will always say to people I work with, you have to trust me when I tell you, if I've got you some information, I will tell you exactly how and where I've got it from. And if anyone is giving you information and they say they don't know, or they don't know who got it, then I think there are questions to be asked. I wanted to briefly touch on the offshore leaks database that many of you may have come across. This compiles data points from a large number of leaks, and there are people who will argue that maybe some of this information isn't leaks and some of it was procured sort of maliciously and dumped. The first leak, the Pandora, well, the first sort of most splashy one, the one that spawned the film with Meryl Streep, is the Pandora Papers. And I had an instance where we were able to, because they've been around for so long, obtain the underlying documents relevant to a specific British Virgin Islands entity that was featured in the leak, by dint of it having been in the care of Mossack Fonseca, the Panamanian firm that was the source of the leak. And in this treasure trove of largely quite boring documents, we came across something that showed that our client's adversary, the sort of prospective respondent in an anticipated arbitration, had been routinely hiring their former staff and paying them a sort of retainer in retirement through a BVI entity. And there was one single document in probably about 2,000 documents that were in the Mossack Fonseca folder for this stuff. And it was absolute dynamite in the context of the anticipated arbitration with their Russian distributor, and that they were trying to sort of take a step back from, shall we say. But they then had to decide, at great length, whether or not to use it. And ultimately, we arrived at the conclusion, I can see the time flashing up, we arrived at the conclusion that if there's been a film with Meryl Streep in about the data leak in question, then chances are that that data is public enough that we can all collectively decide that we're happy to introduce it into these proceedings. That's probably not a very legal assessment, but do add to that if anyone wants to. I think maybe I'll leave it there, and we'll have some questions.
That's an interesting cases. When all went wrong and when all went good, maybe?
Well, I mean, we've done the all went wrong. Okay, there's one more that one of the things that I suppose I'm always terrified of. I've put this quote up. This is from the FT quite recently. Is becoming the story, and as investigators, it's something that we don't necessarily want to happen, if I can put it that way. I prefer to remain in the shadows, and I prefer to be able to provide documents that can stand on their own 2 feet and not feel the need necessarily, in most instances, to have to put my head above the parapet, put my name to the information. And the CT group one there, and this has been the subject of litigation in the High Court in the UK. What happened basically is they bank transaction data was submitted in the context of High Court proceedings. The other side contested it, said none of these transactions ever most of these transactions never happened. Where did it come from? And then what emerged was this, again, chain of, we hired a subcontractor and we don't know who they got it off, but they have access to a database at the ECB and it has all the transaction data in. And the ECB said, no, we don't. And as a result, what's emerged is this situation whereby it's not clear if this is real information or it's been forged and someone has just sold, up the chain of investigators and subcontractors, sold some information that's just been completely made up again. I think there's one other case, I suppose I can mention briefly if I'm allowed, which it was a non-public arbitration in DIFC, but the award has now been made public because of some subsequent proceedings in open court in New York. And in that one, what's fascinating to me as an investigator is how the role that investigators played on one side, a huge amount of work that was done, became, if you like, the sort of central battleground in the whole dispute. And this resulted in, a lot of investigators in London worst nightmare, which is receiving a data subject access request, which may result in you having to disclose every document that mentions the name of the subject that you're researching, shall we say, and a range of other things. But I think it emphasizes to me how important it is to not necessarily feel too much pressure from clients who are asking constantly for results, and making sure that you're doing everything in a manner that you are comfortable with. And you would be comfortable if, in the unhappy situation that you found yourself being cross-examined on your work, or the FT deciding to write a piece about you, that you would, not get a knock from someone who works for a law enforcement agency or something along those lines. Which is not what any of us want, and not what any of the lawyers want either, and certainly not what the clients need. Okay, I'll leave it there.
Just there are some seats in front if you'd like to come and sit down. So from a Luxembourg perspective, I think most of it has already been said by Marie-Hélène. Provisions are very similar. We put them up there. Case law is always much longer to change in Luxembourg. So as of today, the Luxembourg courts will not accept evidence obtained by unlawful means, such as a hidden camera or a telephone tap. Marie-Hélène mentioned earlier on that you cannot record, for example, a General Assembly without everyone approving it. So I think we all had clients coming in saying, oh, I have the evidence. I recorded such meeting or such phone call. Obviously, we're very happy this evidence exists, but we cannot use it. It's criminal. So it's true that that's a big issue. We do have a decision of the Supreme Court from 2007 in a situation where there was a video that was taken by a camera that had not been declared or authorized by the relevant administrative authority. Here, the evidence coming from those cameras had been rejected both by the first instance courts and the Court of Appeal. The Supreme Court overturned that, saying that it's not because it came out, because it was not an authorized video, a camera, that you could not take the evidence coming from there. At the end of the day, when it went back in front of the Court of Appeal, it was still rejected. So we don't have any new case law, especially like you have in the past few months. I would tend to say that having similar provisions, probably our courts will tend to move towards that, but no certainty yet. But I think Fabio wants to mention a war story that we had.
Very quickly. It happened to me in terms of the lawyer's duty to come across evidence which was taken from a third party, apparently legitimate. And when we confronted the third party, because there still was a doubt with these pieces of evidence, third party said, absolutely not. This is not coming from us. We never saw that evidence, so we deny. And though there, of course, you have to stop, because you have the proof that this evidence is most probably forged and cannot be used. But this actually happened. Thank you.
Yes. Yeah. Before I start this introduction, I think I have to apologise to my fellow panellists on behalf of my shoulder, which is touching the touchscreen and causing the chaos. So don't worry, the offices are not haunted. We've established that. So moving on to our second section about tainted proceedings. And I'd like to do that just by talking about a very recent English case, the judgment which came out at the end of February, so sort of within the last month or so, which is just pretty extraordinary just by sort of repeating the facts. So I'll just run through those very quickly. A company called Contacts started an arbitration claim in the English High Court to enforce a Kuwaiti arbitration award. It said that the defendants had some gold investments that held on its behalf to the value of about 50 million euros. It said it obtained an arbitration award in Kuwait, that the defendants had tried to appeal that to the Kuwaiti Commercial Court and failed. The application to the English court was signed by someone claiming to be a solicitor, and there was a witness statement from the company, someone claiming to be the managing director. The award and the appeal judgment were exhibited to the application, as you would expect, perfectly sort of standard procedure. Went to a judge to decide it on paper, again, all very straightforward. The judge, as you would expect, when you're faced with being given an award, an appeal, an explanation about it all, made the order without notice, permitting the award to be enforced. It was then served on a company within the defendant group in London, sort of normal. The claimant then applied for third-party debt orders over bank accounts held by various banks in the UK to the tune of £70 million. And funny enough, when those accounts were frozen, the defendants paid attention to that and were trying to work out what had been going on. And it turned out that the award and judgment were complete fabrications. The defendants then tried to set aside the enforcement order, and they put in evidence from the secretariat of the arbitral body saying that there were no arbitration awards involving the defendants in that period. There was correspondence from the Kuwaiti Ministry of Justice saying there were no judgments involving those parties. I think most surprising of all was quite a sort of detailed analysis of the award. And when you put it side by side with a completely unrelated English judgment on something else and involving different parties, the wording had been lifted from that English judgment. And someone or something had been quite clever and sort of changed the names of the lawyers involved and all of that sort of thing. But genuinely extraordinary proceedings, and that I hope will sort of serve as our introduction to this second topic. Sebastian, you have some views on this.
I just wanted to mention that I love this story for lots of reasons, some of them the same as you, but I think that the process that someone, whoever they are, my new hero, went through to work out that the award was effectively just a rewritten judgment of old, it makes me very excited. I see my job as being to try and spot when fraudsters make mistakes, and that is such a fantastic example of that. And I assume some sort of software that allows people to find plagiarized academic work was probably used, or something similar. But anyway, just wanted to mention that.
Thank you, Laden. So, French perspective on fraudulent arbitration, fraud in arbitration. Let's talk about two different matters. One is very unusual. One is the Vasarely matter. It's in the world of art. You've heard probably of the Hungarian artist Vasarely. He gave part of his art collection to the Vasarely Foundation, and when he passed away, there was a dispute between his heirs and the Vasarely Foundation, because the heirs considered that most of the works of their father went to the foundation, so they wanted to take part of it, and they imagined doing it through an arbitration, thanks to the president of the foundation, who was the daughter-in-law of the painter, a lawyer who organized the whole arbitration, and the heirs. So they organized a dispute between the heirs and the foundation, and the lawyer organized the arbitration in such a way that at the end of the process, the heirs were granted a 40 million euros award that was paid in the works that were in the museum. So the heirs took all the paintings, and a few years later, this situation led the foundation almost to bankruptcy, and a liquidator investigated on the matter and discovered a note from the lawyer who explained to the president of the foundation how, thanks to arbitration, they could obtain the payment and the work of art. So there was a criminal investigation, after which it was discovered that the councils acted under the direction of this lawyer. The arbitrators acted under the direction of this lawyer. So it was a whole sham arbitration. So of course it was cancelled by the Paris Court of Appeal that set aside the award as sham because of fraudulent consent of the parties to the arbitration. So this was a major case because it involved a lawyer. The lawyer has been disbarred. It involved a very famous art collection. All the paintings have not yet been recovered by the foundation. If you go to Gord, you can see the museum. Some of the paintings are still, I think, in America, in the residence of one of the heirs. The other topic, I'm sure you've heard of it, is the tapis matter. So the tapis, for those who are not aware of the French cultural life, Bernard Tapie was he passed away a few years ago. He was a French very successful businessman and a politician. He had a dispute with Crédit Lyonnais and Crédit Lyonnais subsidiary SDBO. After many years of dispute, they decided they signed an agreement to submit their dispute to an arbitral tribunal. And the arbitral tribunal rendered an award in favor of Bernard Tapie. He awarded the liquidators of Bernard Tapie's former companies an indemnity of 240 million euros, and the tribunal awarded an indemnity for damage to Bernard Tapie of 40 million euros. Many people had doubt about the independence and impartiality of the tribunal. There was a criminal complaint, and it was discovered that one of the arbitrators had a long-standing connection with Bernard Tapie and Bernard Tapie's lawyer, and that arbitrator organized the work of the tribunal in such a way that the two other arbitrators, which were very famous and very highly respected arbitrators, relied on him. And this arbitrator, he organized everything with the lawyer. So again, it was a forged arbitration. And after a criminal investigation, after a criminal sentence by the Court of Appeal of Paris, the Court of Appeal of Paris withdrew this arbitration. So here we have two different examples of sham arbitration, thanks to which, and there are plenty of others, but we don't have time enough, I'm afraid. But the interest of it is just always to keep in mind that, of course, as counsels, we want the success of our client's claim, but and we want, of course, that our client be granted a defense, but there is a limit with it, which is to behave properly as a lawyer and to fight against fraud. We know, especially in France, since various recent case law, that there can be intentional offenses linked with arbitration, such as complicity, concealment of information, concealment of status, and money laundering. In this kind of offenses, the counsels, to be liable, must have intentionally participated to be convicted. But there is, of course, a gray zone, because apart from criminal liability, we have, as lawyers, the obligation to ensure that the award will be enforceable. And that's what you mentioned, Marie-Hélène, before. We also have to avoid being in a gray zone when we are manipulated by our client, and we know that this may happen. So we have an obligation to know who our client is. This is a rule in France and in EU, to know our client. So the first takeaway for us today on this aspect would be always to make sure of who is our client, who instructs us, who pays our fees, who gathers the evidence. And this is mainly a big duty of vigilance on our shoulders.
So, from a Luxembourg perspective here, we wondered what type of obligations laid on the lawyers at the moment of the proceedings. And so one of the questions was, if you have a suspicion of criminal offense, should you run and do your reporting or not? So you will have an obligation to report if the money laundering, if there is a money laundering purpose of the arbitration, and it has to be obvious. So clearly you understand that your client is launching those arbitral proceedings solely to launder money. There's another question, is if there is criminal investigation going on, what can you do? So in Luxembourg, I think you have the same principle in France. There is the principle that the criminal law has precedence over the civil law. So usually civil proceedings will be stayed pending the criminal proceedings. Yes, fine, but what about arbitration? We have a new law since 1 year, and in this new law, the arbitrators are authorized to equally stay the proceedings pending the criminal proceedings. What happens if, at the end of the day, the arbitrators consider they should not stay the proceedings and go ahead? That's where the question of enforcement kicks in. And when we prepared this panel, there was an interesting comment, which was, it's often different lawyers who are in charge of enforcing the award. So somehow, all those obligations we've discussed, you have to look into it all again. There is a Swedish decision which was handed down by the Supreme Court in August 2023, by which a Swedish lawyer was convicted of money laundering for obtaining a repayment from the Swedish enforcement authority and forwarding it to his client, despite suspicion that the money was originally obtained by the client through fraud. This lawyer was sentenced to 2 months in jail. So we do have big obligations here. And I think the case you mentioned earlier on is an interesting one. I understand that there is, in parallel to our conference, a conference on AI. AI is coming, and it seems that this award has been totally forged, probably, and then from it's issued with AI. And I think we're going to have to be very careful. We have all seen this American lawyer who cited cases that did not exist. I tend to say here it can happen too. A client comes over with an award. How can you know whether it's faked or not? So probably that'll be a question for you, Sebastian, afterwards. But I'll give over to Fabio for the Luxembourg perspective.
Yes, about the Tainted award. So, of course, the enforcement of an award which potentially tainted may breach public policy. Now, if it breaches public policy, of course, the general principle, which is also valid in Luxembourg, of fraus omnia corrumpit, is applicable. And recently there was a decision by the Court of Appeals in Luxembourg, which ordered a stay of the exequatur proceeding of the arbitral award because there was a criminal complaint filed, and the criminal complaint resulted in the opening of a formal investigation. That is a requirement. And that investigation was for forgery of documents and use of those forgeries, judgment fraud, and the laundering of the money resulting from this enforcement. And now, based on Article 5.2b of the New York Convention, which you clearly know, this decision of 2021 said that it is absolutely necessary to suspend the proceedings, waiting for the final decision by the criminal court or the dismissal of such proceeding, depending, before this exequatur validation order can be issued or not. So that is a very recent decision which validates this basic principle of fraud and applies the New York Convention.
Well, under French law, unsurprisingly, fraus omnia corrumpit applies too. And we've put some decisions on the slide, but of course, if there has been some procedural fraud in the arbitral process, the award is maybe set aside or denied enforcement under French law. Interestingly, sometimes there has to be a demonstration that the fraud had an effect on the arbitral tribunal's determination on the merits. If the fraud was already if the subject of the fraud has already been debated before the arbitral tribunal, and the arbitral tribunal decided not to take into account the fraudulent evidence, for instance, the award may be safe afterwards. But if it wasn't raised before the arbitral tribunal and then we discover there has been a fraud, of course, the award may be set aside or denied enforcement. A specific feature of French law, maybe, is that it results from various recent decisions that allegations of fraud may be raised after the completion of the arbitral process, at the stage of the enforcement or setting aside proceedings against the award, even if the facts which give rise to these allegations were known by the party raising it. You can, to say this in the simplest way, you can keep that to yourself until you can put it to some use, you know, if the award is not to your taste. And this is why do we accept that? Because for the greater good, to be sure that we can set aside or deny enforcement to tainted awards, which should not have been obtained because they were fraudulently obtained. So, what about the Council's perspective? If the award was not forged, but you suspect that there may have been some fraud in the process, or if the other party is starting to make allegations of fraud when you start the enforcement by, I don't know, sending a letter. I'm thinking of one of our cases where we had an award to enforce, and the other party said, well, there may be some, you know, some wrongdoings on the merits. We may have to challenge the award. Well, in this case, it seems that these allegations are just a way to avoid enforcement of a perfectly valid award. That's our opinion. But what I mean by that is that at the enforcement stage, you have to be careful, because even if there was no allegations of fraud or anything before you were engaged on this case, it may arise, and you have to warn the client that it may still affect the validity of the award and its enforceability. And maybe I will leave it to that and give the mic to the English perspective.
Thank you. I'll be very brief. I think wrap up with reference to another case that has sort of been pretty big news in England. I'm sure in Europe and elsewhere as well, which is the Republic of Nigeria case. Judgment came out last year, and just very briefly, there was an arbitration back in 2017 where PID had been awarded some $6.6 billion as part of that award. Nigeria, very, very late, came to the English court to challenge that award on the basis of bribery and corruption and perjury, including within the arbitration process itself. And the judge found that PID had submitted knowingly false evidence because they hadn't disclosed the fact that they had paid a government official, not only in relation to the underlying contract, but also in relation to the arbitration which followed. And so the judge was pretty taken aback by that, I think. There were also issues about PID lawyers being given privileged documents and not returning them to Nigeria and saying we haven't read them, etc., as they ought to have done. But I think one of the most extraordinary facts from that case is the contingency fees that PID's lawyers were on. So if you haven't heard this, brace yourself. The counsel, the barrister, was on a contingency fee of £850 million. The solicitor stood to earn up to $3 billion if the claim and enforcement had succeeded. So something to think about when we're talking about, you know, the duties of counsel to deal with documents properly and so on. And in that sort of case, that's pretty extraordinary.
Thank you very much for your attention. I'm sure there are questions in the room or comments. our experience to be shared. You're right.
Good afternoon. Thank you. That was a really inspiring and illuminating panel. I'm really honored to be here. I'm just a 50-year law student from Bologna, so I'm very honored. I would have loads of questions, but just one I'm curious about. In the case when there is like a criminal investigation going on, which is parallel to an arbitration proceeding, maybe involving one of the parties to the arbitral proceeding, could we hypothetically say that the evidences that have been produced from the criminal investigations could be held admissible in the arbitral proceeding as well, without that going against principles of equality of the arms and fairness between the parties, and especially involving the principle of confidentiality around the criminal investigation, especially when that involves corruption, fraud, bribery, all things that could in some way undermine the enforceability of the award later on if it is found, perhaps. So I've been reading a lot about it, and I was curious to hear your opinion, especially with regard to Valet's point about the Cour de Cassation experience. Thank you.
First thing is that it will depend, and that's the whole purpose of our discussion, it will depend on the rules of law protecting the confidentiality of this information in the different countries, because criminal proceedings may happen in several countries and you will not have the same rules applying. It's easier to use evidence when it has been made public one way or another, or you can so that's why sometimes you stay the arbitration proceedings, for instance, waiting for the outcome of the criminal proceedings so that you are sure that you can use the outcome without putting your award at risk by using some material which you maybe shouldn't have used. I don't know if I'm answering your question in very general terms, but that's why you know, obviously, that you do not have in several jurisdictions, and that would be the case in France. The arbitral tribunal doesn't have to stay the proceedings and to wait for the outcome of the case, but it may find it relevant and useful if the arbitral tribunal thinks that something really relevant to the outcome of the case may arise from the conclusions of the criminal proceedings. So I would have a very careful answer, but sometimes I may add a point, which is that sometimes in the course of the criminal proceedings, you are made aware of things, facts, for instance, which may be useful and which you may retrieve by other ways. You know, you just have the information and you have to find a way to be able to find some evidence you can submit without any risk. So it's useful in this way, just to have some indications of, you know.
Just call Sebastian.
And just call Sebastian. I should have just answered that.
Thank you.
But you have to be careful, of course.
Yes, hi, I'm Stavros from Cyprus, for all those who don't know me. Even though we are a common law jurisdiction, even though usually we follow English precedent quite closely on common matters, we have departed and chosen the American precedent in rejecting illegally obtained evidence. Doesn't the UK recognize the supremacy of the European Convention of Human Rights over its local laws, so as evidence obtained in breach of human rights is not admissible? We do, by the way. But we do have a constitution and you don't.
Well, sort of going back to day one of law school, we do have a constitution, but no one's written it down anywhere. And the joy of that is it means you can argue whatever you want about what the constitution is. I think I said during my sort of presentation, I think The origins of that approach in England comes from the fact that disclosure is so important, because there's no choice on behalf of a party. Let's say a party has got, through whatever means, some sort of material that was obtained improperly. It can't make a sort of positive choice. I'm not going to use that material, so I'm going to lock it away in my safe and forget I ever had it. Because the very fact they have the document showing that material is relevant to the case and therefore has to be disclosed. So I think that's the way we approach it. And the other way we sort of guard against human rights abuses is the emphasis on lawyers behaving properly and sort of being the guardians of what their clients should and shouldn't be doing. That obviously isn't a perfect system, because clients go and do things before they engage a lawyer, they go and do things against advice and so on. But I think that sort of the role of lawyers is considered to be incredibly important, and that's why we're incredibly committed to the European Convention, despite what you might hear from the sort of outer fringes of the Conservative Party at the moment.
Hi, I'm Rufus Abel from Amsterdam, a lawyer. It's great that we have this event, and grateful to have the arbitration week here in Paris. But I would like to give a warning as a counsel perspective to everyone in the room here, because what I understand is that you can actually get defrauded in French top Michelin restaurants. Because sometimes there are apparently chefs, world-renowned chefs, that like to feed you good bottles of wine, and then after you've had the third one, they put a sale and purchase agreement in front of your nose and just make you sign it. And the bad thing is that in France, apparently, you don't need a civil law notary like you do in the Netherlands to transfer shares in a company. And I actually know one case where that way there was a defrauded share transfer. The joint venture partner whose shares were taken was not really happy. It took them 5 years, I think, to get the Michelin star chef to actually pay a large sum of money in the UK, ultimately, because the French court said no evidence of fraud. Of course, it's hard to prove that there was fraud, but apparently the UK found it convincing. So watch out when you eat your escargots tonight.
Well, thank you very much for your attention. And thank you for this gastronomic image, which was very relevant, because you know perhaps that yesterday the Michelin awarded its stars, so you are perfectly online with the actuality. So it was a great privilege for us to host this event, and a great privilege for us at Elerion to have such friends as BSP with Fabio and Laure-Hélène that organize with us this event every year. So thank you so much, Fabio and Laure-Hélène, and also thank you so much, Jason. We enjoy very much our relationship with Peters and Peters, and we were very proud to have you here. So thank you for your participation. And thank you, Sebastian, for being the investigator of the panel. Your contribution was really essential for this topic, so thank you very much. So now let's go for drinks. And thank you very much again for your presence and attention, and see you next year here for the Paris Arbitration Week.